protecting your innovation with IP or intellectual property. The first thing to really say about this is that IP isn't, it's just a thing that's been invented by us. It's not, it doesn't exist on its own. So what it really is a set of laws that are designed to help creators or people who generate R&D to make some money out of the fruits of their creative efforts by basically moderating competition for the products or the results of what they do. So it's a diverse collection of rights. It's not a single thing, and every company, in some respects, has a different way of using the IP system. So before I begin, who here runs a company or is an entrepreneur? About 10%. Who here just wants to flip their company in a couple of years and make a few quid? All right. You might as well leave now because I have nothing to say to you. The IP system is for people who want to build long-term large companies. It's not for the people who are trying to make a quick buck. So if you stay till the end, I'll give you the top five things you need to know. If you want to flip your company, it doesn't really matter one way or the other because it'll be too late by the time you sell it in a couple of years. IP is for the long term. So there's a few kind of very basic high-level things about the IP system that are worth knowing. The first is that the IP system protects the embodiments or ideas, or the expression of ideas, and not the idea itself. So, for example, the idea of detective books is not protectable by the IP system. But, for example, Sherlock Holmes is, because it's a specific example of a detective book. And similarly with patents, with most forms of IP, that's the case. Secondly is that they're property rights. So what does that mean? Property rights means that they exist in their own right through a legal mechanism. So they're not attached to a person. So for example, a patent is a patent. It can be bought and sold. It can be traded like any other piece of property. Whereas a contractual right, like a trade secret, depends on the relationship between the people in that contract. And a trade secret can't exist outside of that kind of contractual relationship. So it's important to know and to know the distinction. So what that means for companies is that you can trade your IP in a way that's independent of your products. So if you're J.K. Rowling, for example, you can license Harry Potter to a movie studio to make a movie, or you can license it to somebody who makes merchandise without having to do it yourself. Or you can sell the idea to somebody else. And then the third thing is, and related to that, is that an IP right gives the owner or the person who has a right in it the ability to exclude other people from using it, to go to a court to enforce that exclusion, to transact and to get value from that. So what do I mean IP is for the long term? The reason I say that is because IP in general takes a long time to build up and to realize, particularly for technology companies and again for brand-based businesses. So for example, a patent, which covers inventions, technical inventions, it takes about 3 or 4 years to get a patent granted. It costs multiple tens of thousands of euro, but once you have it, it'll last for 20 years. A trademark, again, has to be registered, and once you register it and renew it, it can last indefinitely. But a large effort has to go into building up the brand equity in a trademark. Similarly, there's things, there are two types of design rights. One is registered and one is unregistered. And they, again, have to be filed, protected, and invested in to realize the value of the asset. Copyright is a standalone right in that it doesn't need to be registered. So if somebody creates something original that is copyrightable, the copyright exists from the time or date it's created. There's a typo in the slide. The lifetime of copyright is 70 years after the death of the person who created it, after the death of the owner. So it lasts for a very, very long time. So for example, the copyright in the works of James Joyce has only recently expired. He died in the 1940s. Similarly with Sherlock Holmes, the copyright in Arthur Conan Doyle's works have only recently expired. And the important thing to note here as well for technology companies is that the primary IP right for software is copyright. So, there's good and bad news about that. The good news is that all original software is copyright. The bad news is to infringe copyright, you have to copy it, and it doesn't protect independent creation. So if somebody develops something similar or similar functionality to your software, there's nothing you can do unless they've actually copied your code or used your code to make that copy. So just to use this as an example here, and to show that in many cases there's a set of overlapping rights. So we don't have a laser pointer, but in this example, which is a well-known yogurt drink or fruit, or I'm not sure what you call it, but these kind of nutraceutical type things where they build in stuff into the drink to make it health benefits. So for example, here you might have patents on the packaging technology. So how do they get the little tin foil lid stick to the bottle and not to fall off? Or how do you make that little cardboard thing, or make a machine to make it? Technology for filling the bottles. So a lot of technology goes into most foodstuffs today. Trademarks then is the brand aspect. So if you're very good eyesight, you can see there's a little R here in a circle beside Actimel, which means that Actimel is a registered trademark of Danone. And that means that when you see the word Actimel, you know that product has come from Danone, who owns the trademark. And the purpose of the trademark is to tell consumers the origin of products, so that you know when you buy a can of Coke, it comes from Coca-Cola, and you know when you buy a can of Pepsi, it comes from Pepsi, and from nobody else, or doesn't come from anyone without their permission. And that's the function of a trademark. It designates the origin of a product, so that consumers can associate with that name certain quality, sentiments, and other things that give it value in and of itself, irrespective of brown fizzy liquid that's in the can. Similarly, as a kind of complementary right, there's industrial design in this. So the shape of the bottle, for example, the way that the packaging looks, all benefit from design rights. And big companies or sophisticated companies will have a very large range of design filings to cover their packaging, which complement trademarks. So trademarks designate the origin of the product, whereas design rights protect the appearance of a product. And both, obviously a trademark has an appearance, it has a word or it's a logo, but the design rights can offer complementary parallel protections that make it much more difficult for somebody to copy or to use similar types of designs. Finally, graphic works also benefit from copyright protection. So somebody cannot just go and copy this or make something that's a derivative work of it without infringing the owner's copyright rights. So the message from this graphic is that most companies should be looking at a holistic type of approach to IP that looks at different layers of protection for their products. And particularly for kind of consumer businesses, the trade, the brand aspect and the design aspect has a very strong role to play in building up the value and strength of their product. So I'd just like to say a little bit about trade secrets and a bit about information rights as well. So trade secrets is confidential information which has value because it's confidential. So the secret formula, the algorithm, whatever. So they're not classified strictly as IP rights because they don't benefit from that kind of tradability in the same way that copyright or patents or trademarks have. But they will still be within that broad category of intangible assets that support most businesses. And actually a lot of businesses, knowingly or unknowingly, have a lot of trade secrets. So a lot of know-how, a lot of stuff is confidential that if it became public would reduce the value of the company. Through contracts, so through your NDAs, through your employment relationship with your employees, and then for legal protection, and then in practice through policies and procedures to prevent confidential information being disclosed. The other thing to note is that a trade secret for technology is what turns into a patent if it's filed. So a trade secret embodies an invention, and if a company or a business decides to file a patent, it documents its trade secret, files it with the Patents Office, it then becomes a public document, and eventually may be granted as a patent. And just to note, there's a new draft European Trade Secrets Directive which aims to harmonise trade secret law in the European Union. There isn't a huge amount in relation to Ireland because we have a long, well-established trade secret law. For Eastern European countries, for example, will have a cultural distrust of secrecy laws. The intent here is to have one law for the whole of the European Union, so that's developing. I don't have a slide on it, but I'd just like to talk about information rights as well, which are related to trade secrets, and particularly for software companies, where a lot of software companies focus on trying to patent their software. But look, software today is very easy to copy. The functionality of it is easy to copy, and there's very weak protections for software functionality for public policy reasons. So, and you can see that through the open source movement, where a lot of very high quality software is now open source or becomes open source, down to the operating system level for Linux or the Apache stuff, across a wide range of functionalities. And actually, many software companies make a lot of use of that for value. So, from my perspective, the software as a tool for processing information is what gives us its value. So the value is in the proprietary information that's in your software product, not in the software itself. So it's important for software companies to look at themselves as information companies as much as software companies. So the example is something for your accounts software. So the accounting rules are set by revenue. You have no control over that. It's a very basic front end, back end system setup. But once a user has their account information in it, it's very hard to switch. So that's what gives software its stickiness and gives it its value. So this is kind of so why is it important for innovation? So what it really means here is that it gives you, it basically suspends the normal rules of competition. So if there's perfect competition, all profits will be competed away if there's no barriers to entry. So what IP rights generate are barriers to entry and barriers to innovation. And it also, in a fast-moving, dynamic innovation ecosystem, it gives you the ability to realize value from your R&D, even if you don't exploit the end product. So that's what it gives you. So, for example, Intel chip manufacturer. Nobody today could set up Intel because Intel has such a huge IP portfolio that it would be impossible for somebody, even if they had the money, to manufacture competing chips and not infringe Intel's intellectual property. And that's what gives Intel a huge barrier to entry and creates that duopolistic market structure with Intel and AMD. So just a few practical tips. So for the people who are in it for the long haul, it's to just have some conscious effort around IP and to look at your own business and look at your environment from an IP perspective, and then to invest if your strategy demands that. So I'm just coming to the conclusion of my talk, and very, very personalized view on 5 things that most companies need to know about IP. So, number 1, lawyers. So, do you want to have Dean and Jerry or Len? Do you want somebody who wants you to go to jail or somebody who wants you to walk free? Because both sets of lawyers are out there. And in particular, if your lawyers make more money when you sell your company than when you stay independent, you want to make sure that you understand that, right? So it's very important if you want to build a long-term business. And I'm not saying it's wrong, either is right or wrong, but if the people who are advising you benefit more when you sell than if you stay in business, then you have to think about that. So there's lens and there's D's and Jerry's. 2, patents. In my view, patents are for big companies. A lot of data coming from the US shows that most technology companies spend 1% of their R&D revenue on patenting. Most technologies, on average, technology companies spend 10% of their revenues on R&D. On average, a US patent costs $30,000 to grant. That means you need to have revenues in the region of $30 million to afford a patent in the long run. So that's the kind of scale, an order of magnitude type scale of companies that use the patent system for long-term benefit. Obviously there are exceptions to this, but particularly in ICT and software telecoms, the patent system is for big boys, or boys who are in it for the long run. So if you want to sell your company after 2 or 3 years, it's unlikely that patents will make a difference unless you have exceptional technology. 3, you often see companies who will spend hundreds of thousands on patents, but hundreds of euros on their contracts. For most companies, their contracts are more valuable than their patents. You should spend accordingly. 4, this is very important about brand. There's a point of view that says that brand is incompatible with tech companies. To that, I just say the word Google. So the value cycle for brands and technology looks a bit like this. A very badly drawn S-curve. So tech usually starts off valuable because you're solving a unique problem, but the value diminishes because as you start solving it, other people start solving it as well, or they start working around your technology. So in the long run, Google's technology at the time was unique in serving up and indexing internet searches, but nowadays you can get that technology as an open piece of open source software. I can get it on my phone. So, but as their technology value decreased, their brand value increased because people associated with the word Google, which is just a word that described at the time a very big number. It had no meaning outside of that. They associated certain emotional attachments and brand attachments to the word Google. So nowadays, anyone on their laptop can do a Google effectively, but they can't be called Google. So if you're looking, even if you're a tech company, it's worth bearing in mind that the value in the long run often transfers from the technology into the brand, and not to lose sight of that. But the other important thing is brand starts off with no value. It's just a word or a symbol, and so value is built into a brand. So value in a brand doesn't come from owning it, it comes from developing a reputation. The 5th and final tip is you have to understand where your money is coming from and what strings are attached to it. Because if your funders want you to sell your company in 2 or 3 years for a relatively low value, but you don't, the chances are they'll win, you lose. So you have to understand the conditionalities, both written, implied and explicit. And also even Enterprise Ireland is a type of VC in many respects. So you have to just bear that in mind. And if your VC is on a short cycle, again, don't ask them to put money into investing in long-term IP because they just want to flip the company. So that's it. Thanks very much.